Good morning, students. I hope all of you are well. Okay, today we are going to start the next section of our course, that is contract law. And one of the big chunks in our course is related to the contract law. It is mostly scenario-based, application-based, and obviously a bit of it can be tested via knowledge-based questions. And if you remember in the beginning, I told you some questions are knowledge-based, which are of few marks, 1 mark, and usually the application-based questions are 2 marks questions. So this is a very, very important area of our course that we need to focus upon. We will take a start with the idea of what a contract is, what are its main elements. In the first section, we will study that the first thing about the contract is its elements. That is the formation of the contract. It is divided into 2 major areas in which we further will discuss 4 sub areas. And it will be spread over our 3 sessions, today, the next session, and the next. After that, we will discuss what is included in the contract. And afterwards, the last section will be about what happens if one party breaks a contract. What are the consequences? Now, remember, the first important thing to remember is that this is included in the private law section and the civil law section. We have studied these distinctions earlier in the first session. So we are going to discuss mostly about it in a sense that it belongs to the civil law domain of the law. So let's get started with it. First thing first, what is a contract? We need to have a solid definition. Obviously, in the paper, you're not required to define it, but in order to form the conceptual understanding of any concept, we first have to refer to its definition. And definitely, you can consider a definition like a seed. It is not visible later on. When you sow it, afterward, the plant comes out of it. So whenever we are discussing a new concept, first of all, we discuss its definition so that we can discuss about it later on, and all the other further elements and concepts sprout out of that. So what is a contract according to UK law? A valid contract is a legally binding agreement. So this shows us that first of all, it is an agreement. And for agreement, we understand that one person cannot agree with himself. It doesn't make any sense. So there have to be at least 2 parties. So for agreement, there have to be 2 parties amongst which will the contract be formed. I'll come to what legally binding means in a while. Formed by the mutual consent of 2 parties. Means there will be mostly, in most cases, we'll be discussing 2 parties. Mutual consent means both party agree to making that contract, and that is implied in the agreement word as well. Now, legally binding means once a contract is formed, then both parties are bound. There actually a contract creates an obligation on both parties. When they agree to do something, it creates an obligation of both parties that then they both have to do what they have agreed upon. Now, if one party backs off, the other or does not want to fulfill their part of the obligation, the contract says that the other party, they can take them to the court. And if you remember in the civil domain we discussed, if anyone could, one of you could remind me, what is that party called in civil law case which initiates a case? Anyone in the chat section? The party in the civil law. Excellent, Avishka, very good. Okay, so that is called the claimant. And very good, Ritesh. Claimant, in simple words, when we use a generalized term, it is the injured party. If you remember, I told you injured party in law does not mean that he has been hurt physically. If we want to if you want to tell that we are talking about physically hurt person, we use personal injury. So here in this case, we have two parties. One party has backed off, that is the default party. It is not performing its part of the contract. So the other party whose rights have been violated, that is the injured party, when they go to the court and file a suit, that is, then they will be called a claimant. So then law takes into action and further proceedings go on. So this is the basic definition, and we will further discuss about these definition in detail. Now, what are the essentials of a contract? There has to be an agreement. Excuse me. And when we say agreement, it means between two parties, one party will make an offer and the other party will accept it. So offer and acceptance, these are two primary parts of a contract in agreement. In today's session and the next, we will be discussing in detail about the offer and acceptance. Second is the bargain. Bargain includes obligation and value, or in law terms, we say consideration. Now, consideration means something of value. When both parties agree on something, obviously they are offering something of value in return for something of value. For example, I agree to sell my car to somebody. What is his consideration? He is getting car from this agreement. What am I getting? I'm getting cash or the payment. That is my consideration. So it has to be something of value. Third one is the legal intent or intention to create legal relation. Usually, when I agree with somebody, for example, if I have a friend and I say that, okay, fine, if you pass your exam, I'll take you to dinner or I'll take you to lunch. This is an agreement. This is an offer and acceptance, but this is usually in the friendly manner. I did not intend to create a legal relationship. We'll discuss all these elements in great detail over the next 3 sessions. But what you need to remember here, in this section, what we will be focusing on, what are these terms and what are these terms not? Or, for example, what is an offer? And according to law, what is not an offer? This is very important because you see, in order to form a contract, the essentials must be complete. So the first thing then what parties do, for example, coming back to the earlier discussion that the default party, one party has made a default and the other is the claimant, goes to the court. So the default party, first of all, would like to establish that there was no contract at all, which I am bound to follow. In order to do that, they will have to deny any of these. For example, if they can prove that there was no offer, if then they can prove there was no agreement, or if they can prove there was no valid consideration, or they can prove that there was no legal intention. So this means if any of these is missing, the contract is not formed at all. So what am I obligated to perform? So this is the first thing that we will discuss. So from the paper point of view, when you get a scenario, you will have to first see, and usually it will be tested that whether there is an offer or not, whether there is an acceptance or not, whether there is valid consideration or not, whether there was legal intention or not. So this is the first step. Once it is established that there was a contract, then we will go later on what was included in the contract, and then later on what is the duty of the default party if it is proven that he is liable. So this first part is very, very important. Okay, now before going into further detail, we have to have some background concepts when we discuss about the contract making. First is inequality of bargaining power. Now, what does inequality mean? When two parties are uh, forming a contract, it is possible that they are both on the same level, same grounds. For example, I want to sell my car and there is somebody who wants to buy my car. For him, there are so many sellers. For me, there are so many buyers. So I am in no way bound to sell the car to him only. No problem. We have equal bargaining power. If we don't like it, he can go his way, I can go my way, no contract formed. But sometimes what happens is that both parties are not at the equal bargaining power. For example, a in very simple scenario, I will ask you, let me know. If a person is performing a job, he's an employee somewhere, who do you think has more power or more bargaining power, the employer or the employee? Under normal circumstances, who has more power, right? That's right. So what we usually see is law in employer. Sometimes they take advantage of their power of being an employer, and the employee may suffer. So employee in this case will be the weaker party, and employer will be the stronger party. Similarly, in the relationship of seller and consumer, who would usually be the person with the higher power? Seller, obviously, because you see sometimes what happens is that a simple example, that when we buy something online and when it reaches us, we see that, oh, it is not what we wanted, and the seller may refuse that I have described it clearly over there. For these things, law then will intervene. Now let us read this paragraph and you will understand what I'm saying. Freedom of contract, number one, this is very important. Law allows two parties to enter into any form of contract as long as it is legal. That is the primary requirement. So obviously, the deal of some illegal items, it will not be a contract. So that is the primary thing. So freedom of contract means, in principle, parties are entitled to enter into agreements as they see fit. Whatever they seem suitable. For example, if I want to sell my car, other person wants to buy my car, no restriction on that. It is legal. No restriction. However, where two parties make an agreement, they invariably have different levels of, if they have in different level of bargaining power. Many contracts are made between experts and ordinary consumers. You see, experts and also they have special power. They are they're in a better position to make judgments than a consumer. For example, if I were to buy a laptop from a seller, I will go, and maybe I'm not that much expert in this. Is my first time buying a laptop. I'm not very familiar with the technicalities in it, but the seller is. Now this gives him a better bargaining position than I. So the law will, this is very important. The law will, as long as this is happening, freedom of contract, law does not intervene. Whatever legal contract you want to make, you make it, no problem. But the law will intervene only where the former takes unfair, former means experts or the person with a higher bargaining power, takes unfair advantage of their position, and not simply because one party was in an inferior bargaining position. So, okay, fine. What does this mean? I know about the laptops as well, but he as a seller is in a better position. So I want to suppose buy a Dell laptop, but he convinces me to buy another new company's laptop, very not very much well known, but because that company is giving him more profit margin, so he wants to push their products. He wants to sell their products, and he convinces me. Now in this case, I'm not a actually a person who does not know computers very well, but he being in a better bargaining position can exploit that position and take unfair advantage of this. In this case, law will intervene. Now remember, law intervene does not mean that the judge will come himself. How would he know? I will have to go as an injured party to the court, and then law will intervene. Otherwise, if there is a general contract, both parties have equal bargaining power, law does not intervene in that. We will later on further discuss upon these when we will be studying the chapter of consideration. Okay. The other thing in relation to this, then we have consumer protection laws. The development of mass market for complex goods in the last century means that the consumer no longer rely on their own judgment when buying sophisticated goods or service. Consumer interests are now served by two main areas: consumer protection agencies and legislation. See, you can see we have a bombardment of advertisement. Every product seems very good. When we see an advertisement on Facebook or Insta or any other social media, it attracts us. It seems that it is the product that we want to buy. For example, I am very savvy to this, I'm very prone to this, I get bombarded with these kind of information. For example, recently I bought uh, some jams and pickles just because the ad was very good. Similarly, I like to buy new type of clothes, so I get all the time these bombardments. Now here, what usually happens that online, when you see a product, because of the photography and videography and the animation and things like, it seems that it is the product may be way, may seem way better than it actually is. Now I am buying, if I'm buying just by watching it, and the seller is in a higher bargaining position to convince me, law will intervene. How does it intervene? In UK, we have consumer protection laws. Later on, we will discuss about these, but here you need to know that we have consumer protection agencies, which include organizations such as Financial Conduct Authority and different legislation laws. Consumer Protection Act, we'll study about it in the contract law. Generally, I'll give you just one example so that you are familiar with it. For example, in the UK, if you buy a product online and you made your decision just by watching the picture or looking at the picture. So what happens is that, for example, uh, I ordered a uh, mirror for myself just by looking at the picture, and it seemed very big. And when I received, suppose it was this, what do I do? In the picture, it seemed like a whole big 2 feet mirror, but when it received, it comes on the my palm top. Can I sue the seller? Actually, no. The law says that the seller is bound with the description of the or object it is being sold, not the picture. So what should I, as a consumer, should have done? I should have scrolled down. I should have checked the dimensions. First of all, the seller is bound to give dimensions. How big is the object? So it will give in inches or centimeters or whatever feet. So I should have looked at that. Had I looked at that and it was clear over there that it is about yay big, then even if I bought it thinking that it is a big one, if he has given the description. Now remember, it is not for him to ensure that I read the description. It is for him to ensure that the description is given. That's it. If I don't read it, that is my fault. So this is how law works. But if he has not given any description and he's projecting the product to be way bigger than it actually is, then I can sue him. So this was just an example that the sellers are bound to describe the product and sell the product as per description, not as per picture. This is how law protects the consumers as a weaker party. Similarly, we will later on study about the employment contract. We have full 2 chapters on that, and we will discuss how law protects the employees as the weaker party. Okay. Now, battle of forms. This is another very interesting concept. Even though our course does not allow us to go very much in depth of that, you just need to understand the basic concept. You see, on your right side, I have given a snapshot of when you want to uh, make a Gmail account initially, or any email account, or any online form. They give you a form which obviously as a consumer we never read. When you go to a bank, they give you a form. It is written in yay tiny language. We don't read it, we just sign it. Now, this is an example. Do you think we can create a Google account if I do not check this? No, it will not be permitted. It will not let me create account. I have to check it. This means that this is a standard form. This is Google's standard form. If I want to avail their services, I have to agree to these terms. These are non-negotiable. I cannot make changes. I cannot say them that, okay, clause number 3, 4, 5, I don't agree with that, or make certain changes. No, it is a standard form. This is not an issue because it is a standard form and I am a consumer. I don't have my own form. But What happens when both parties that are entering into commercial agreement both have their standard form? For example, firm A and firm B, business A and business B, company and company B. They both have their standard contracts and both want to enter into the contract based on their standard form. Then a problem arises. But then you will have to go into negotiation and things like that. We don't talk much about it in the course, but you need to understand that it can create a problem. So disputes sometimes arise in commercial agreements because each party is accustomed to doing business in its own standard contract and argues that they apply to the contract rather than the other party's terms. Great care should be taken during the negotiation stage to clarify which standard terms will apply. Where it is not clear, the contract must be considered objectively by taking into account what has actually happened. That is called the factual matrix. So, two organizations, they may have dispute, and obviously later on the law or the court will decide which standard form needs to be taken into account, and from that point onward the court will decide. Then, okay, all right. uh, this is the background of the whole situation. uh, Now we will move on to discussing in detail with what we discussed in the start, the definition of the contract. And from here on onwards, we will discuss now what is an offer and what is not an offer. That is the first segment of our today's discussion. What is an offer and what is not an offer? Remember that. Why is it important to understand what is not an offer? Because in the scenario, you will have to search out that one party said something, but that was not an offer. So offer is the first element. If it is not there, there is no contract. We need to remember that. So sometimes a statement may seem like an offer, but it will not be an offer and hence no contract. But first, excuse me. But first, let us discuss what is an offer. Now, one person shows interest in doing something or not doing something. This is very, very interesting. So, to form a contract, it is not necessary that you do something. You may also promise to abstain from something or from not doing something with a view of approval from another person. Meaning, an offer is made with a view, with an intention that other parties would agree to it. If that is not the intention, there will be no offer. For example, if I'm telling somebody my car is worth $10,000, it's just an information. It's not an offer. I have not shown any. Had I told him that I want to sell my car to you for £10,000, would you agree? Then that would make an offer. So first of all, one person shows interest in doing something or not doing something. So I explained to you what is doing something, selling my car. What is stopping from something? For example, I ask my friend or anybody, please, I would like you to stop smoking. It's not a good thing. But if you stop smoking, I pay you some amount of money. Or if you stop smoking, I would pay you a for a month or 2 months or a year, I'll pay you this much amount. So it is about not doing something. Both are okay. So offer can be about doing something or about not doing something, or we call it abstaining from something, stopping myself or oneself. Abstain, to get abstained. Okay, an example here. John offers to buy bike from Zach for 50,000. This 50,000 is in brackets. I don't read it, but for the first time, just I'm telling you, this is the consideration. We will talk about it in later part when we'll study consideration. That's why I'm not talking about this at the moment, even though it is a valid part. John offers to buy bike from Zach. Here, John has made the proposal to Zach in order to obtain assent. Assent means agreement or consent or approval from John to buy his bike. Okay. So now in this case, John is the offerer. Now, I want to clarify one very important point. John offers to buy bike. Please let me know who is the prospective seller and who's the prospective buyer in it. Who's going to be the seller and who's going to be the buyer? Yes, please. Anyone? Okay. So here, John is the buyer. And from Zach means Zach is the owner, so he is the seller. At the moment, the situation is that John offers to buy bike from Zach. John is making an offer, so John is offerer in this case. He is the offerer. He is initiating. He is the offerer. Here is my question. Who will be the offerer if the situation is reversed? Situation reversed is mean Zach is still the seller. John is still the buyer. But what if Zach tells him that I want to sell my bike? At the moment, John offers to buy bike. John is initiating. He is saying that I want to buy bike from you. But if John was there and Zach tells him that I want to sell my bike to you, now the tables will turn. He will still be the seller, but in this case, John will become the offerer. So offerer does not mean that who owns it or who buys it. It means who is making the first initiation, who is making the offer. That is the offerer. And the reverse of offerer is offeree. The person making the offer is called offerer. The person who is receiving the offer is called offeree. Then acceptance. Once the offer is made, obviously an acceptance cannot be made if there is no offer. This is the very basic idea that you need to understand. For example, if I go to somebody and I tell them that, okay, fine, I've heard that this car is very good. I will buy it from you. I'm not making an acceptance. Actually, I'm making an offer. If it's something it is, I'm making an offer, not an even it sounds like an acceptance, but acceptance can only happen once there is an offer. Remember that. So the person to whom offer or proposal was made shows consent, agreement, assent. The proposal is said to be accepted. So in this case, David offers to buy a bike from Sam, which Sam responds positively, means he agrees to it. Here, David has made an offer and Sam has accepted it. The person accepting the offer is called offeree, or when it is accepted, he can also be termed as an acceptor. For example, up till this point, David offers to buy bike from Sam. Here, David is the offerer and Sam is offeree. But as soon as he accepts it, he becomes the acceptor. Now, first important legal point. Only that party to whom the offer has been made can accept it. I repeat, only the party to whom the offer has been made can accept it. Example. Suppose in a party there is Mr. A, Mr. B, and Mr. C. Mr. B and C are all three are in the same area. They are just on the same table. They are just chatting, discussing. And in the meanwhile, Mr. A says that, okay, fine, I have a nice car. I would like to sell it to you. And he tells it to B that I will sell it to you for £5,000. Now here A is the offerer, B is the offeree. Suddenly C says that, okay, nice, that's a good offer. I accept. Is there a contract? No, there is not, because A did not make an offer to C. Number one, that is very important. Another important thing is that an offer to be valid, it must reach the offeree. Now, when there is a face-to-face discussion, it is very obvious that I'm talking to somebody, I'm making an offer, it has reached him. What about if I post a letter making an offer? For example, I send a letter to another person in another city and I am making the same offer that I want to buy your car for £5,000. Only when the letter reaches him, then he can accept it. If the letter does not reach him, this means the offer has not reached him. So we understand two important legal points here, and these will be tested later on in different case studies. Number one, only the person to whom the offer is made can accept it, no other party. And second, the one to whom the offer is made, he must become aware of it, in other words, or he must receive the offer. You can use both words. He must receive the offer to be valid, or he must become aware of the offer. For example, what does it mean? Here in this case, I have a friend, we have a friend C. A and B have a common friend C. A is trying to communicate to B, but he is not getting hold of it. He tells C that whenever you meet Mr. B within a month or so, tell him that I want to sell my car to him for 5,000. So you see, now when C, maybe the next day, he meets B and tells him that your sell is off or whatever the reason, A has offered to sell you his car for 5,000. Now, in this point, remember, C cannot accept it because the offer was not made to him. Offer is for B, but he is the communicator. So as soon as B receives this offer, now he can accept it. This has a very important legal foundation, and we will discuss about it later on. So at the moment, you need to understand this concept. Please let me know if the situation up till this is clear to you. If you have any question, please feel free to ask. If it is clear or no questions, just write it. Anyone else? If anyone have any questions? Okay, now, up until now, whatever we have discussed, I will summarize into this shape. First of all, a proposal or offer is made, and to whom it is made, it is called the offeree, and he will make the acceptance. At this point, because we are only discussing two elements, that is the offer and the acceptance, we are not discussing others, so we will not call it a contract at the moment. We will say it is a promise that is made. For example, this is the offerer, this is the offeree, and the promise is made. To promise, we add something of value, which is known as consideration. If there is no consideration, if something of value and something of value from both sides, and this is also a very important legal aspect. So going back to the earlier example, if I tell my friend or anyone that if you achieve this, if you get good marks, I will take you to dinner. Now remember, what is that person getting out of it? The dinner. But what am I getting out of it? Nothing. If he gets good marks, how does it impact me? If it does, then fine. But normally it does not. If my friend gets good marks or degree, or if he passes exam, he's not going to give me any of his income. He's not going to give me any of the title. It's just benefiting him, not me. So that is no return, meaning every consideration from one side must be reciprocated by the other side. For example, in all of these cases, we said that John is selling a bike. John wants to buy a bike for this much. So bike is consideration for one party, cash or payment is consideration for the other party. So this something of value has to be there, and it has to be from both parties. Then it will become an agreement, still not a contract. So in order to make a contract, for example, Robert offered to buy his computer from Z for $50,000, to which Z responds positively. Here, Robert's promise, another thing, very important. Remember that payment right away is not important in law. A promise of payment is also fine. So for example, if I tell somebody that I would sell my car to you after 1 month, and he says that, okay, fine. After 1 month, I'll bring you the cash. So at the moment, neither I have transferred the car nor he has made the payment, but both have exchanged promises. So promise of payment or promise of execution or promise of doing something or promise of not doing something, both can be considered as valid consideration. So no problem at all. So here Robert's promise to pay 50,000 in consideration is consideration for Z. Z's promise and Z promise to sell computer is consideration for Robert's promise. So let's start from the beginning. Offer was made, acceptance was done. That makes a promise. To promise, there has to be something of value from both sides. It becomes an agreement. Now comes a very, very important part of law. That is the enforceability. Remember, we said it is a legally enforceable. How does a contract become legally enforceable? It needs to have three elements. Then it will become a contract. What are those? Number one, legal. Legality, possibility, and intention. Now, legal, what does it mean? Now, here you need to remember two important terms. Number one, object of contract, and number two, subject matter of contract. Object and subject matter of contract. Object means purpose, the reason for the contract. And subject matter means the things or considerations. For example, first remember that the object and subject matter of the contract both have to be legal in order for contract to become legally enforceable. If either of these is illegal, the contract is void. It's not a legal contract. So it cannot be enforceable. Now, what does it mean? For example, uh, I go to an arms store, a weapon store that sells weapon, and in my country, selling of weapons is allowed as long as I have a license for it. I go to the arms dealer and he asks me to show him his license, and I show him the license, and he asks me what is the purpose, why do you want to buy the this firearm or a gun or a pistol or whatever it is. I tell him this is for self defense, or it is for sports. I want to go hunting and I want to buy for that. Now, what is the subject matter? The gun. What is the object? Hunting. Hunting is the object or purpose of this contract. He tells me, okay, fine, give me this much advance and I'll bring that required gun tomorrow to you. That is a contract. Now, both are legal. This means that the contract is legal. If he later on refuses to pay me, I can take him to the court. If later on I refuse to buy the gun, he can take me to the court. So the object and subject matter both are legal. Now, in a situation, it normally doesn't happen, but let me, just for the sake of example, if he asks me and I tell him that what is the purpose of this gun that you want to buy, and I tell him that I intend to kill somebody. Obviously, it is, I will not tell him, but suppose, only for supposition. Now here, the subject matter gun is still valid because it is allowed by law, but the object murder, it is invalid, it is illegal. So the contract is not legally enforceable. Just a minute, please. Okay. So now the object, purpose of the contract, murder, it is illegal, but the subject matter is legal. Now, if even if he makes the contract with me and later on he refuses to sell the gun to me or I refuse to buy the gun from him, neither of the parties can take to the court. This is not an enforceable contract. There's no contract at all, basically. Another example, for example, drugs. There are certain kinds of drugs which are only permitted for medical purposes. So if I represent a pharmaceutical company and I go to a seller and I want to buy a certain drug that is for pharmaceutical purposes, object is legal, and for that particular object, particular good is legal. Both are legal, valid contract. But suppose I want to buy a product which itself is banned, which is illegal, either for pharmaceutical purposes or otherwise. Now, I want that product for some legal research, for some pharmaceutical research, for some medicinal research. My object, medicinal research, is legal, but the subject matter, that particular drug, it is illegal. So even if I make a contract with somebody, that contract will be illegal. So I hope that is clear, these two areas. Remember this word object. In English, we say object is something. In law, object means purpose. It will come later on again and again. Object of something means purpose. Object of a company, object of a business means purpose of that business. And subject matter is the things about which we are making the contract. Okay. Next is the possibility. Okay. Possibility. For contract to be a valid contract or enforceable, it is important that whatever is to be performed is also a possible thing. If it is not possible, the contract will not form. Now, there are two situations to it. One situation is at the time of making contract. And second, after the contract is made. What does this mean? I'll give you examples of both. Something that you want to do at the moment when you are making the contract, it is not possible. So the contract will not be made. But in the other scenario, at the time when you were making the contract, that was possible, but later on it became impossible. So these are two different situations. First of all, when something is impossible to be done, is impossible to be done at the time of making contract, the contract is not made at all. That is called void contract, or in other words, we can also call it a void ab initio. Please give me a minute. I have to give some jam to my baby girl. Just a few minutes, please. Okay, so that is called void ab initio. Ab initio means from the very start. So void is a term, we'll come to it later on as well. Some contracts are valid, means okay, they are okay contracts, all the agreements are, all the requirements are there, it is enforceable. But if it is not enforceable, there are different situations, one of which is void. We'll come to it about an invalid contract and a unenforceable contract later on. Now, I'm going to give you an example. For example, I have a piece of land which is barren. No crops can be cultivated on that. And I agree with somebody that I will grow crops on it and I'll sell those crops to you. Now, this is impossible because the area is barren. So this contract will be void ab initio from the very beginning. But suppose I have a fertile land and I agreed with somebody that I will grow crops and I will sell them to you. At the time of making the contract, the land is fine. But crops take about 4 to 6 months to develop. After I made the contract, after 2 months, there was a big flood or an earthquake over there. And because of that, all the land has the fertility, the soil has gone due to erosion, etc. And now it is not possible to cultivate any crops on that for next 5 years, maybe. So in this case, the contract becomes void at a later stage. And then there are certain complications to it that we will discuss later on, that what is the other party's right. My right is that, okay, fine, it is impossible for me to make to grow the crops now. It is out of my hands. So impossible is like this. So but one important point that you need to remember: impossibility does not mean financial difficulty. Remember that. For example, if I told him that I will grow crops and will sell you from my own produce, suppose say cotton, I told him that I will give you 100 tons of cotton from my own produce, this particular land. And if that land is gone, I am not bound. But if I told him that I will give you 100 tons of cotton, that's it, not specifying from my own produce, then I am bound. This is a very slight distinction between these two, very fine distinction, sorry. You see, in the first case, I have specified the source. In the second, I'm not specifying the source. So in the first, when I specify the source and that source is destroyed, I'm not bound to honor the contract. But later on, but if I told him that I will give you 100 tons of cotton, I did not specify from where, then I will have to manage it. It is available in the market. It is not something that is unique, only I can produce it. It is in the market available. But if I later on say that no, in the market it will be very difficult for me, or it is financially difficult for me, or if it becomes very costly for me, I'll make a loss. Making a loss in law is not the main thing. Law will not look at my loss. It will say that you agreed 200 tons of cotton. It is available in the market. If suppose it is not available in the market, the government has put a ban on the import of the cotton, then obviously it is illegal, not in my hands. I cannot do it. So we will touch upon this portion in the chapter of consideration later on in at great length. But for now, you need to remember, in order for a contract to be enforceable, it has to be legal, and second, it has to be possible. Two things. Now, the next area, intention, as I told you earlier, intention to create legal relations. Now, things that we have studied up till now, those can be easily identified. There was an offer or there was not an offer. From the wording, from the scenario, we can understand that. The legality, illegality from the law. Consideration is either service or a good, we can identify it. Problem is with intention, because intention is there in the mind. What was I thinking when I was entering into this agreement? Now, intention, for example, two parties, they are in a dispute, and one party says that I did not intend. Yes, there was an offer. Yes, there was consideration. Yes, it was legal. Yet this was possible, but it was not my intention to create legal relation. Now the judge has no way of identifying, entering into the mind of that party, whether he had the intention or not, or going into the past in a time machine and looking at the scenario that whether he had an intention or not. It's not possible. For that, law gives the judges two presumptions, two areas. Based on that, they will decide whether there was an intention or not. Now, those two are whether these two parties, what kind of a relationship these have. If there is a domestic relationship, a family relationship, a personal level relationship, non-business relationship, non-commercial relationship, then the law will assume that yes, there was no intention. No intention, hence no contract. But if these two parties were in a commercial relationship, the scenario was commercial, the dealing was about a business deal, these two are not related to each other, then the presumption will be that yes, there was intention to create legal relation. Now I repeat, Intention is the state of mind. It cannot be judged. If one person is saying, I did not have any intention, there is no formula to judge whether there was intention or not. So the law gives judges two presumptions. Judge will look at their relationship. If it is proven that it was a personal relationship or a domestic or a non-commercial relationship, then judge will consider that there was no intention. But if both parties have a commercial relationship, a business relationship, then and the surroundings, the environment in which the contract was made was also business environment, then the judge will consider that there was an intention to create legal relation and hence there was a contract. Remember, sometimes students get a feel or a meaning from this discussion that there can be no contract between family members. This is not the case. I'm not saying that. All I'm saying is that whenever there is a dispute and the dispute is about the intention, only then these presumption will come into play. For example, if I make a deal with my brother about buying his house, it is a perfectly normal contract. I can do that. But the problem will arise only when my brother goes to the court and says that I did not have any intention to create. Only then this problem will arise. Otherwise, there is a fine contract. I give him the money, he hands over the house documents to me. Fine, it is a valid contract. So the only problem is that when there is a dispute, only these presumption will come into play at that time and not before that. Okay. So finally, what is the effect of the contract? Meaning, when one party has made an offer, the other has agreed, there is consideration involved, it is legal, it is possible, and intention is there, meaning a contract is formed. So it creates both parties, meaning both parties have now to perform something and is enforceable by law. Meaning, if one party, injured parties may sue the default party for not fulfilling their due obligation. This is known as the breach of contract. When one party defaults, it means that they have breached their contract and the other party can take to the court. Okay. With that, we'll take a short 7 minutes break, 6 minutes break, and then we will reconvene our session. Okay. Must a contract be in writing? Now, up until now, we have discussed that there has to be an offer, there has to be an acceptance, there has to be, it should be legal, it should be possible, and there should be legal intention. We did not discuss that it must be in writing. This means that the law does not require the contract to be in writing, and it can be a very um, um, strange thing to say or understand, that how can a contract be if it is not written? But the law does not require contract to be written. So we use the term simple contracts. Simple contracts are those contracts which are not required to be in writing. They can be verbal. And this is a very important point of law. The thing is that, however, that it will be difficult to prove the contract which is not in writing. But that is not our domain. Usually students ask me that, sir, then how will we prove it? And remember, in the very first section where we studied that what are the purposes, why do ACCA student have to understand law, or why do we study law? It is just to get a basic understanding of the principles. How it can be proven? There are ways, but those are for the lawyers to do. Remember that. For you, because you are going to be business executives, you need to understand that even if you make all these essentials available, then the contract is there. So you have to be careful in your daily routine life. So when you want to make a contract, you have to ensure that you bring it in writing. Otherwise, verbal contracts are also possible. Now, in some certain circumstances, the contracts are required to be in writing. So, a simple contract, no written required. But law also states that there are certain circumstances in which certain form of contract should take place. For example, there will be some contracts that must be by deed. Deed is an official document. Deed is a government approved document on which the contract is made and then approved by the government officials or notarized. Some contracts, they may not be required to be in the form of a deed, but they should be in writing. And then there are some contracts which themselves do not need to be in writing, but their evidence has to be in writing. I'll explain these one by one. So general time limitation to sue in a contract is 6 years. This is the time limitation, meaning if one party defaults, the other party has 6 years to sue them. If 6 years has passed, under normal circumstances, they will not be allowed to sue the default party. Okay. Contracts by deed. Now, this 6 years is general. If a contract is by deed, its limitation is 12 years. Which type of contracts are required to be in the form of a deed? Lease agreements, when you get some area on rentals. If it is less than 1 year agreement, then no need of deed. If it is lease for 3 years or more, then it has to be in the form of a deed. Conveyance or transfer of legal estate in land or a mortgage. Mortgage is when you uh, get loan for your business, and return you hand over the documents to the bank to keep them safe, and or legally you tell them this: if we are unable to pay you back, this is the amount that you can this is the asset that you can sell and get your money back. In our course there will be a great deal of discussion in company law when we will reach there. A promise not supported by consideration. A while back, I told you that every consideration must be reciprocated with another consideration. But Sometimes it happens that a promise is made from one party to do something, but not in return, but not for a promise of return promise of something. For example, you make a covenant, you make a promise to pay a certain charity that I will give you this much, for suppose £1,000 a month to you. You have made a promise from, but you are not getting anything in return from that charity. So that is a promise which is not supported by consideration. You're not getting something back. So what happens? That contract is valid, but only if it is in the form of a deed. If it is not in the form of a deed, that charity cannot come to me later on that you promised, I can deny it. Okay. One important point that I've forgot, this word consideration. Usually in law, we say consider or consideration when we are thinking something. So in English, in plain English. But when we are talking about law, we say consideration is something of value. So there is another word, contemplation. This is used when we are when we want to say that somebody is thinking. So both parties are in contemplation. This means that both parties are thinking about the contract. But when we say both parties have passed consideration, this means that they have exchanged something of value. So you need to remember sometimes this word contemplation will come, and you need to know that contemplation means to think about something. Okay. So this was the type of the contract which must be in the form of a deed. Second are that must be in writing. So they do not need to be in the form of a legal document, but on at least a piece of paper or a company letterhead, it has to be there. So a transfer of shares in a limited company, the sale or disposition of an interest in land, bill of exchange and checks that I'm sure you would have checks, at least you would studied in FA1, financial accounting. Bill of exchange is also a sort of uh, a negotiable instrument that is used in the transactions and for future payments. So that also has to be in writing. Consumer credit contract. Credit contract means that, for example, a bank has to give out a loan for a to me for a laptop or something like that. So these are credit contracts. These have to be in writing. Last one is the contracts evidenced in writing. These can be made verbal. The contract itself can be made verbally, but its evidence must be in writing. For example, A and B, they are making a transaction. They are entering into a contract. A is the seller, B is the buyer, and the amount is suppose £1,000. A says that I will give you this loan, or I will give you these valuables, these raw material, or whatever it is. This contract itself does not need to be in writing because this is a general sale purchase contract. No need to be in writing. But A says that because you are a new person, I would require a guarantor, somebody who can guarantee on your behalf. So he calls in Mr. C. Mr. C guarantees him that, okay, fine, if this is a contingency, if B does not pay you, I will pay you on his behalf. So the original contract between A and B needs not be in writing because that is the original contract. But this guarantee contract has to be in, in writing. You see the difference? The main contract can be without in writing, it can be verbal. But if the guarantee contract is there, that guarantee has to be in writing. So this original contract is evidenced in writing. So this was about the different areas. Now, just a minute. If a contract is complete in all its elements, that is called a valid contract. But sometimes there are other possibilities. But so we in English we use the word invalid, but in law we do not use the word invalid. We use void or void ab initio. If any of the essentials is missing, if there is no offer, no agreement, the capacity, will come to it in a while, legality, consideration, these are not there, then it is called a void contract. Voidable contract is that contract is signed by misleading a party, for example, where the innocent party decides where it wants to continue or disregard the contract. For example, a person promises to sell his car with a brand new engine, but the engine is actually used. It's not brand new. So it is deceiving the other party. When the other party comes to know about it, the contract becomes voidable. Voidable at the instance of the injured party, meaning that it is up to the injured party. For example, Mr. A and Mr. B. They agreed to sell a car for 10,000 pounds, and Mr. B said that I will give you 2,000 pounds a month. So this is for 5 months. Mr. A says that the car engine is brand new. In the third month, after paying 2 installments, in the third month, after paying 3 installments, sorry, after the payment of the third installment, Mr. B comes to know that the car engine was not actually new. He was suspecting something. He went to a mechanic and he came to know that he was being misled. He was misled. Now, it is up to Mr. B whether he wants to continue the contract or he wants to cancel out the contract. This is called voidable. What happens to the money and that we'll discuss later on. But it is now here, remember, Mr. A cannot end the contract. It is not up to him. Only Mr. B can end the contract. This is called voidable at the instance of the injured party. Third is unenforceable. Unenforceable means all the essentials are there, but it was to be in writing and it was not in writing. It was to be in the form of a deed, but it was not in the form of a deed. Then even though all the essentials are there, it cannot be taken into the court of law because law already said that it has to be in a specific form and it was not. We'll study some more concepts related to the contract when it comes to the validity. Number one is the capacity. Capacity means the mental capacity or the age, two things. Mental capacity and age. So for age, one who's below 18 years in law in UK, that is called a minor. And minors cannot enter into contracts except for necessities. Except for necessities. What does it mean now? I'm going to explain to you and then I'll ask you a very interesting question after that. For example, Mr. A and Mr. B, and B is a minor. Mr. A is a seller of, say, grocery items. He has a small shop. Mr. B comes to him and asks him to give him goods worth 20 pounds, essentials, for example, grocery. Some grocery items, some oil, some flour, some meat, etc., something like that. And he promises that I will pay you tomorrow. First, let's see if all the required elements are there. B is making an offer. If A agrees, then it will be agreement. For him, for B, consideration is the essentials or the grocery item. For A, consideration is 20 pounds. Is it legal? It is legal. Is it possible? It is possible. Both have intention to create legal relation. Okay, fine. Now, he says that I'll pay you the next day and takes the items. But because he's a minor and because the goods were necessary items, if B does not pay him tomorrow, A cannot sue him because in the eyes of law, B was not did not have the capacity to enter into the contract. So A cannot enforce him. Here, a question may arise in the students' minds that what if A does not know? Well, there is a concept in the law of reasonability. If you remember, we discussed about it previously as well. You see, a shopkeeper in an area, he usually knows people around. So if a person is coming to him, he does not necessarily need to check his documents whether to understand whether he is a minor or not. So a person, a boy who is about 10 years old, he can physically check that yes, he is not 18 years old. So it is reasonable that he knew that he was not. For example, the boy was about to turn 18 the next day. Today is the last day of his 17th year, and tomorrow he is going to become 18. Now, in this case, that can be a serious situation that the person may say that I did not know. But it is very obvious the boy will not change drastically within one day. It can be seen that he is almost 18. So you see, the law will take it into a reasonable consideration, reasonable contemplation, that did A know or did not know. But that is not the point of discussion here. I just explained because some students ask this question. The point here that you need to remember is that A cannot sue B later on because he's a minor, and the goods were essentials. Change of scenario. Suppose the same scenario is there. B comes to buy something for $20, and that is a luxury coat. A very nice piece of coat. Obviously, it is not for 20 pounds, but what is, let's say, okay, 200 pounds. The money does not matter in this case, remember. Now, B asks A for luxury coat, and he's still a minor. In this case, because a luxury coat is not a necessity, if A sells it to him, he can later on claim this amount from B of the luxury coat, and B cannot say that I am a minor. In this case, sorry, my apologies, I went a bit reverse. For essentials, he can claim. For luxuries, cannot claim. My apologies. If the goods that are given to the minor are necessities, then the seller can claim the amount from him. But if these are for luxury items, then it cannot be claimed. The amount cannot be claimed. Remember this. I went a little bit reverse. So if a minor comes to me and he wants some necessities, I will give the necessities and I can claim that later on. But if it is a luxury item, if it is a non-essential item, not necessary for life, and I give him that, I cannot claim it from him later on. For example, he comes to me and buys a car from me and tells me I'll pay later on. I cannot sue him later on because he's a minor and car is not a necessity. Now, a twist in the situation. For example, B comes to B and B is still a minor. It is very cold, harsh winters. The boy does not have anything to cover himself and he wants a coat from him. But this coat is with gold studded buttons. You know, it is a nice coat, very warm, but it has some gold studded buttons. And A sells it to him. Later on, can A claim from B or not? Or if it can claim some amount or some not, what could be the situation? You can write your answer in the chat section. Let me repeat the question, the scenario to you. B comes, still a minor. He comes to A, wants to buy a coat to protect himself from the harsh winter. Mr. A sells him the coat which has gold studded buttons on it. Can later on Mr. A claim the amount from B or not, or some part or some not? Avishka, that is the basic idea that you need to understand. You see, now in this case, this one quote can be distinguished into two things. The quote itself is a necessity, but the gold studded buttons are not the necessity. So in this case, the law will decide what is the worth of the quote minus the gold studded buttons. For example, if it is about $2,000 quote, the court will decide that the gold studded buttons that were about, suppose the quote is about, say, £2,000, and out of which 1,800 is for the gold studded buttons and 200 is for the coat. So the coat part is the necessity for which the minor has to pay, but the 1,800 is for the gold studded buttons. Those were not necessary, those were luxuries. For that part, the claimant cannot receive any money. So generally we see it like this, that for necessities it has to be paid even if these are minors, and for luxuries he does not have to pay. Okay. Okay. Next is the intoxicated part, or mentally retarded. Somebody who is under the influence of an alcoholic drink at that time, for the time he's under the influence, he does not have the capacity. If he makes a contract, that is a void contract. Or if a person is mentally retarded, he is not a minor, a major, but his mental capabilities are such that he is not of a sane mind, then he cannot enter into a contract. Okay. Next is the form. Just like we discussed, if some needs to some contract need to be in a particular form and they are not, then those will be not be enforceable. Then we have the terms of the contract.